I'm Jennifer Brown, editor of Canadian Lawyer In-House magazine, and I'm joined here today by Nikiforos Ayatru and Graham Brown of Weirfolds LLP. Today we're talking about the Competition Bureau's recent crackdown on bid rigging in the construction industry. Nikki, the Competition Bureau has had some pretty high-profile cases around bid rigging lately. Can you talk about the importance of a construction company having a good compliance plan in place in order to avoid some of the risks around the Act?
Trade associations and construction companies should seriously consider implementing a Competition Act compliance program. These are educational tools designed to educate managers or employees of a business about their obligations under the Act. These programs can help workers identify and hopefully avoid risky behavior, and it's particularly important for companies involved in the construction industry, such as road pavers, for example, to have these sorts of programs in place. Companies that are involved in bidding and tendering situations, that are involved in trade associations, and that generally operate in industries that are the subject of greater bureau scrutiny.
Okay, and what happens if you breach the Competition Act in this area? What's the worst case scenario for price fixing or bid rigging?
The worst case scenario is quite bad indeed. You can have imprisonment sentences of up to 14 years. For price fixing, which is Section 45 of the Act, the fine can be as large as $25 million. For bid rigging, it's an unlimited fine. And even for the non-criminal parts of the Act, a violation, for example, of Section 79, which deals with abuse of dominance, that can land you an administrative monetary penalty of up to $15 million.
So Graham, let's say that Gary, the owner of a tunneling company, is going through some tough times, and his friend Larry doesn't want to see him go under, so he withdraws his low bid on the project with the agreement that Larry will get a project in the future, but they don't identify what that project will be. Is this illegal?
It's not acceptable, and in that case, both of them could be guilty of bid rigging. In Larry's case, what he's done is he's withdrawn his bid and as a result reduced the competition on that project. That's to the detriment of the subway owner, as well as, in that case, by implication, the taxpayer. Meanwhile, Gary, who's committed to committing the same criminal act in the future, is the beneficiary of that action. As a result, they could both face a prison sentence of up to 14 years and a fine of an unlimited amount. So at no time should any company think that bid rigging is acceptable behavior.
Okay, thank you both. For more on this and the Competition Bureau's rules on bid rigging, please see the full issue of the quiz in the July edition of Canadian Lawyer In-House.